King, can you hear me?
Loud and clear.
Wonderful. Ship, I see you there. I just sent you a co-host invite, so look on your invite thing there. Hopefully you can join us. And so I will say Merry Christmas and Happy New Year to everyone. Haven't been on here for a while. Partly that's because, if you follow me, you know from my Twitter, we were on vacation. We went to Europe for a few weeks. And hey, Ship. And I caught COVID when we were in Europe, and so I still have a little bit of cough. I couldn't talk for quite a long time because if I tried to talk, all I would do is cough. And the cough is not completely gone, so hopefully it won't plague me too much tonight. But I don't want to go our usual 2-hour marathon because I don't think my voice is going to hold up that long.
So as of 2.5 years ago, the world decided that that was just a respiratory virus similar to bronchitis.
Right.
So
Yeah.
you have the sniffles.
Yeah, exactly. Except it causes me to not be able to get up off the couch or talk. So there you go.
Oh, I got a lot of things that cause me to find myself in that condition.
Yeah. So, okay. Well, so you're preparing for your case now. There's more snow in DC. It's coming down here
Well,
again too. Is it snowing there where
well,
you
we'll
are?
see. We'll see. There's supposed to be I didn't think that we got as much snow as expected, but I think it might be the orientation of my hotel to the direction of the storm, and the parking lot I'm looking at was just sort of sheltered
Mm-hmm.
because I've seen reports that it was, as much as 8 inches in the district, and
Right.
now they're talking about another 4 inches overnight.
Right.
The courthouse was closed today.
Mm-hmm.
Now this is what I'm up against. The courthouse was closed today. So we're supposed to start at 10 o'clock tomorrow. Well, it
Right.
just happens to be the funeral procession for the late, great President Carter
Right.
is going to move from National Airport to the Capitol
Right.
at
To
like
line
11 in
state
the
in the
morning.
rotunda. It's going to go right by the courthouse.
And they're claiming that there's going to be tens of thousands of people lining the streets
In the
as the
snowstorm? I think
procession goes
not.
by. Yeah,
Right.
I don't think so either. But all the streets are blocked off.
Yeah.
But we are still scheduled for 10 o'clock tomorrow morning.
Okay. Well, we'll see. Let us know
And
how that
and, and,
goes.
oh, and oh, by the way, Thursday is now a holiday, so we can't finish the case on Thursday. If we don't happen to start tomorrow,
Right.
I presume we'll start on Wednesday, which means we will never finish by Friday. It's
Mm,
just, it's a,
it's a mess.
yeah.
It's a mess. All right. Well, good luck with that. Let us know how it goes. So tonight we wanted to, since Chip is preparing for his case and I'm still kind of struggling with my voice, we thought we would maybe go for an hour and talk about Judge Marchand's recent rulings. And then back of the book, I don't think that sentencing is going to go on Friday, but the Supreme Court is going to hear the arguments on the TikTok case on Friday. And, fun fact for the Supreme Court of the United States, hell could freeze over. They still will hold their proceedings. So I was telling Chip, when I was in law school, we had the blizzard of 96, I think it was, and the whole city shut down. It was really, really bad. But the Supreme Court held arguments that day. They put out a call for people with four-wheel drives to go pick the justices up from their homes and take them to the courthouse. So the courts keep on trucking even when the rest of us don't. So I do expect the Supreme Court on Friday to hear that argument kind of no matter what. Although that has changed a bit. King, you want to weigh in on that? It's changed a bit, hasn't it, since Rehnquist died? It's not quite so old school.
It will never not be old school. They have their protocols, their traditions. They're going to, come hell or high water, be the Supreme Court.
Right.
I I agree with you. The snow or no snow. They're going ahead, and no matter how liberal or conservative they are, they're the court.
Right. That's how they see themselves. Well, they're not wrong. They're the third branch of government, right? So, all right. So let's talk about Marchand then. So to set the scene for people, so people can understand the timeline. So this is the Alvin Bragg case in New York, Judge Marchand presiding. And Pre-trial, Trump's lawyers said Trump had immunity, right, for stuff that he did when he was president the first time, and that Marchand should not let that kind of evidence into the case. And Marchand decided that he didn't agree with that, and even if he did agree with it, he wasn't going to rule on it pre-trial. He was going to rule on evidence as it came in, which is normally what judges do, except when you have an issue like that, that kind of is a theoretical ground for certain kinds of evidence to come in or stay out. Often a judge will make a pretrial ruling and say this kind of evidence is not coming in or this kind of evidence is allowed. Excuse me. So he could have ruled on it pretrial, but he just didn't want to. So he didn't, and then he let in a bunch of evidence that some of it arguably is not immune, some of it arguably is immune, and I think some of it clearly was immune, and so did Trump's lawyers. And so, but it came in anyway. And then after the trial, the Supreme Court said, well, lo and behold, the President of the United States does have immunity, and you can't use evidence that derives from the president in his official capacity doing stuff, and you can't use it at the trial. And you should figure that out pre-trial so that he can get rulings on that. And just to remind everyone, in the criminal side of the courthouse, you have to wait until your case is finished. Final is the theoretical word lawyers use. The case has to be final. The order has to be final. Judgment has to be final before you can appeal. And that's true in both civil and criminal cases. But there's a lot of exceptions on the civil side for something that you can appeal before the whole case becomes final. And there's procedures for getting a judge to agree to let you appeal before the case is final and blah, blah, blah. But in the criminal side of the courthouse, there's only a handful of things. And honest to goodness, I think it's less than half a dozen of things that can be appealed before the case becomes final. And a criminal case becomes final at the sentencing, not at the conviction by the judge or the jury. So once you've been sentenced, the judge enters what's called a judgment and commitment order. Then you can appeal. But there's a handful of things that you can appeal from. And we talked about this, my goodness, it must be 2 years ago now when this whole thing came up, 2023, excuse me, that, no one, including the Supremes, have ever actually said that immunity, presidential immunity, can be appealed interlocutory as a part of a criminal case because nobody was ever faced with that question before. And I'd done a lot of analysis. I've got a long thread on my Twitter about this, saying that very likely the Supremes would decide that, like this other small handful of things, the immunity can be appealed interlocutory. So before the case is
Well,
final.
can I step in for a second?
Yep.
Don't you know? Don't you know that there was no immunity?
Oh, right. I understand.
So how could you ever try to stay something based upon a legal
That
concept
doesn't
that
exist.
didn't exist?
Yeah, I know. Right. So Mershon, like Judge Chutkan in D.C., said, oh, there's no such thing as presidential immunity, except the three of us were like, wrong. So anyway, the Supreme Court, lo and behold, said, Ship and Leslie and King are right. There is immunity. Surprise, surprise. And so they ruled that this all had to be ruled on pretrial. But Judge Marchand had already held his trial. And so Trump's lawyers raised again the argument post trial, post conviction in Trump's case, that none of that evidence should have come in, and that meant that at a minimum he needs to be given a new trial, and also because that kind of evidence was put in front of the grand jury, that really the whole indictment should be dismissed and the prosecutor's office should have to start over from scratch. So they filed that motion a ways before the election. And Marchand fooled around with it and didn't rule on it, and a bunch of other stuff happened, including the election. And Marchand said he wasn't going to, do the sentencing pre the election, so he didn't. All right, the election came and went. As we all know, Trump was elected. And Marchand finally, on December 16th, ruled on the motion that the jury's conviction should be vacated because of the immunity issue. And he denied that motion and said, oh no, he distorted, twisted, contorted that Supreme Court decision all the fuck out of shape and concluded that somehow it didn't apply the way that Trump's lawyers were saying, and that there was no problem at all. And he wasn't going to throw out the conviction. And so he was going to proceed. But then in the meantime, because Trump had gotten elected, Trump's lawyers were now telling him, oh, by the way, you can't do anything to Trump because he's the president elect. And under the transition statute passed by the Congress to allow for the incoming administration to start to get on board, Trump has special status. And since he's the president elect, and there's this supremacy clause that says, that state judges can't do things to federal officers and all these interlocking arguments, they said, again, you have to dismiss this case, Judge Marchand. Marchand ruled on that on Friday and said, I'm not doing that. I don't find that the president-elect enjoys any immunity. I don't think the transition statute helps you. He didn't go for any of it. And so on Friday, he issued an order saying, I'm denying all these motions by the defense to dismiss, which means I'm going to proceed to sentencing. Now, meanwhile, the government's lawyers, the people, as they call it in New York, the people, Alvin Bragg's office, had asked Mershon not to deny the motion and proceed to sentencing, and I want to know, King and Ship, what you guys think of this. They argued that the case should be held over until Trump was no longer the president. And I'm just trying to figure out, what do you guys think of this? Isn't that sort of conceding the point? Trump's lawyer's point that Trump enjoys some kind of special status in this transition period, and therefore Marchand can't do anything to him now, and so he should do it to him later. I don't understand why Bragg's argument wasn't, that's all nonsense, you should just sentence him now. King, what do you think?
Uh, I think I agree with you. Bragg, um, in essence, said we have to wait. It's best to wait
Right.
until after his term. Uh, but that argument doesn't really deal with Trump's point, which is during the pendency, during his term of office, and actually starting before that under the Transition Act, he is absolutely immune from any hint or taint of prosecution.
Or anything.
So
Marchand can't do anything to him.
he
Oh,
can't do anything, including he cannot hold over his head
right.
a sentence that he hasn't imposed yet. That
That was
that
Trump's
smacks of,
position. Yeah. Go ahead.
and I think he's right on that.
I don't,
But
but you can't do what Bragg did, right? And be like, well, I agree with him, but you should just then continue to hold it over his head until later. How is that the government's position?
I think it has to be. They have to concede that once Trump is sworn into office, uh, nothing on the criminal side can take
Well,
place.
that certainly is true starting on January 20th. But when they were making these arguments, it was back in December.
But uh, there are issues with a sentence 10 days before he is sworn in.
Right, which is what
And,
we'll get to that. We'll get to that, which is why the
uh,
judge decided to show his hand already, right? But what I'm
correct.
saying is, to me, out the government's argument, their only position could be either we agree with Trump's lawyers that as president elect, he's protected, and so that means nothing can happen until later, or we don't agree with that. That's wrong. You're fine, judge. Go ahead and sentence him now. But instead, Bragg decided to do something else and say, well, we kind of concede that he's got a protected status, and that means that you should continue the case. So, to continue with the facts, so Marchand said, nope, I don't agree with that, with Trump's argument. And I don't agree with Alvin Bragg's argument that I can somehow just hold on to this case on my docket for 4 years and sentence this guy later. So I'm going to deny all of that and just go ahead and do the sentencing. But he put in his order that what he was going to do, the the sentence that he was going to give, although he says it's not usually the case that a judge basically says what a sentence is going to be without having first heard from the parties. It is very unusual for a judge to do this. In fact, I don't know if I've ever seen a judge sort of give a preview of what the sentence is going to be. Although that does happen when you're in court, like when you're negotiating with the prosecutor and the judge, often the judge will kind of signal, this is what I'm thinking, talk me out of it.
Can I jump in for just a second?
Yeah, go ahead, Chip.
My take on all of this,
Mm-hmm.
I give none of these actors any credit for even an ounce of integrity. I think
Are you counting
Bragg.
Todd Blanche and the Trump's lawyers, or are you talking about the government
No,
people?
no, no. I'm talking about the
And the
judge
government people.
and Bragg.
Okay, yeah.
Bragg wants to just put the whole thing on ice, and
Right.
he's not going to be the district attorney in 2029 when it comes around. He's going to go run on this somewhere else.
Right.
It's not his problem in 2029.
Right. Well, that was
So
my
he's
point,
happy
that
just to.
his position was not a legitimate government position. That was political Alvin Bragg.
It's right.
Yeah.
It's the Alvin Bragg position.
Right.
He is moving on, and some of the guys that prosecuted this case are seeking counsel to deflect incoming grand jury subpoenas from a federal court, correctly or incorrectly. And Marchand, in my view, signaled what he signaled because he was like, "Just come on, let's get it over with."
Get it over with, exactly.
And then it's not my problem anymore. Or alternatively, I think his play is to force the appellate court to take the case from him.
Right, right. So let me finish, and then we're going to get to that because it is a kind of different strategy options, right? Um, so last week, Marchand said, I'm going to continue. I'm not going to hold this over. I'm not going to dismiss it. I'm going to go ahead and sentence. Nothing's preventing me from doing that. I actually think that's the right answer, my own self personally. Um, Except he should have dismissed the case based on the immunity, but he made that ruling in December and made the wrong ruling. But based on this ruling in January, I think he should have just kept going, which is what he decided to do. Okay, so then he says, I'm going to have the hearing next Friday, and I'm going to give you a preview of what the sentence is going to be. And the sentence, Ship, you and I had said all along, this is a probation case, right? Like this is a no one goes to jail on behind this case kind of case. And I was not aware. It looked to me like you weren't either from your tweets about this New York kind of statutory option, which they call unconditional discharge. Basically means the guy got convicted, but the judge doesn't give you any kind of sentence. You just get your conviction and you move on. And where I practice, you could ask a judge for that kind of a sentence, but it wouldn't be called that. It would be called time served because you get credit for the one day that you got arrested, or it would be a non-supervisory probation. So that's what we.
It is in effect non-supervisory
Right.
probation, but it's a bowing to the reality that even if he gives him probation, which it's a probationary charge,
Yeah.
we'll get to that in a moment. Even if he gives him probation, he's going to have a New York State probation officer supervising the president.
Right, Trump's got to call him every Friday and say, "Well, I'm going to be in Syria next week." So
this is all a concession to reality.
Yeah.
And Marchand probably isn't going to be the judge on this case 4 years from now if it is initiated again. For all I expect he'll be gone. He's just playing it out as the good Democratic apparatchik that he is,
Right.
until somebody else takes it away from him and he doesn't have to make any more decisions.
Right. But on this point about probation, you and I have, I think, both said previously, we thought this was a probation case. Even if Trump had lost the election, we didn't think he should have gotten anything more than probation, and we didn't think Marchand really would give him anything more than that, right?
No.
Right. Well, with one caveat, and can you jump in here in a second? I got to let everybody. I'm actually watching video while I'm doing this my case tomorrow, so I can only stick around here for a few more minutes. I got stuff I still have to do.
Yeah.
It has always been a probation case, but for the government's theory of the case, which Marchand allowed them to argue to the jury, which was that this exercise basically allowed Trump to steal the election, or to attempt to steal the election in 20. No, this was 2016. He stole the election
Oh,
in
yeah.
2016 by keeping
Right.
the Stormy Daniels affair
From the
a
public.
secret
Right.
before the trial. So in effect, his crime resulted in the theft of the presidency. But I guess that's a probationary offense.
Right, which
But
doesn't make any sense either. Go ahead, King.
it's more than a probation issue, though, and I'm arguing on Trump's behalf here. Uh, it's a reputational injury to Trump because by coming down to a final sentence that goes into the records of the court, and then from then on, in all of history, Trump will forever be known as the only president who is a convicted felon found guilty on and sentenced for 34 felony
Right. That's
counts.
why he doesn't want to do the
That-
sentencing. But my point is
yeah,
that what defense lawyers call the worth of the case. This case is not worth more than probation in terms of the penalty. That's all it was ever worth in the real normal world, the way things normally operate. And
but
so,
in politics, it's worth a lot more than that.
right, exactly.
I want to. There's a bigger picture here.
Right, but I never expected Marchand to do anything other than give him probation because that is legally, that is all this case is worth. So I was not shocked and amazed when in his order last week, he said, I'm going to give you what amounts to unsupervised probation. Okay, so that order came down Thursday or Friday. And then today, Trump's lawyers filed a filing with Marchand saying they're going to appeal the two rulings that Marchand made that deal with immunity. So remember, the immunity issues can be taken up before the case is final. Probably nothing else can, but those in Trump's case, but those two definitely can. So Trump's lawyers have been holding this effectively, no pun intended, Trump card that they can take the sentencing off the calendar by appealing the immunity issues. So I looked it up today. It looks like in New York, for both a final sentencing and any interlocutory appeal, you've got 30 days to appeal. So Marchand's ruling on the immunity issue, excuse me, was December 16th. So it looks to me, King, we talked about this on our thread earlier today. It looks like they, Trump's lawyers, waited until this second ruling from Marchand to file their notice of appeal, because otherwise they probably should have appealed the immunity decision back in December and gotten that going. But they were waiting to see if he would dismiss the case based on these other arguments, and he's not going to. So now there's no more reason for them to wait. So they filed today a notice with Marchand saying we're filing this notice of appeal in the appellate court, and also they are seeking in the appellate court what New York law calls the Article 78 proceeding, which normal lawyers would call a writ of prohibition. So this is basically a legal writ like a writ of mandamus or writ of habeas corpus, but a writ of prohibition is an order from the appellate court. Well, it could be from the trial court, but in this case, it is the appellate court telling the trial court, you can't do anything else, you must stop. Now, Ship, we have said all along that, Trump is eventually going to win that immunity argument, right? In some appellate court.
Correct.
Right. So the difference between this procedural posture is he's trying to prevent the sentencing along the lines of what King was just saying, really more for political purposes rather than legal, because the back of the book in this case is that conviction is almost certainly getting reversed, no matter what, whether it's after sentencing or before the sentencing. But Trump, through this procedural device, can preempt the sentencing. So, but again, Ship, here we have the thing, just like we did with Judge Chutkan, that somehow this trial judge, Merchan, doesn't understand that once you file your notice of appeal, he doesn't have jurisdiction anymore. Merchan today denied a stay of the case for sentencing on Friday.
Again, this goes back to the point I made a few minutes ago. I give him no credit for integrity. He knows that's the law.
Yeah.
He knows a case can't be pending in two courts at one time.
Right.
I mean, that's the simple issue of one court losing jurisdiction or the trial court losing jurisdiction when a notice of appeal is filed, you can't have the case progressing under two sets of judges
Right.
because they could be working at cross purposes with one another.
Right. It messes up a whole bunch of legal theories and doctrines like finality and mootness and a whole bunch of stuff. So that's the law. And everybody knows
There,
Right.
it. Everybody
there's a
knows it. Go ahead, King.
there's another wrinkle here. You have a third court
Right.
that all has something to say. That is, uh, Trump filed a removal to take this case as is after the trial and the verdict, but before sentencing. He removed the case uh, to federal court on the grounds
Well, he
of
tried to. Yeah.
he tried a federal officer immunity, federal officer defenses, including uh, federal preemption, and the federal district court denied that. But the statute under which he removed the case gives him a right of appeal. He took that appeal,
Right.
and that appeal is pending in the Second Circuit.
Right.
And the federal law says that until that removal is decided and finally remanded, the trial court cannot, the district court, the trial court in the state cannot render a final judgment, that is a sentence, until the removal issue is decided.
Right.
So you've got two appellate courts with uh, pending stake in this case.
Both of which prohibit Marchand from going final, and both of which he just appears to, be completely ignoring. It's bizarre. So this is
And
what
well, I think there's even a third opportunity teed up for Trump. Let's say he doesn't get the ruling that he wants out of the New York appellate court.
right.
He could run right into the Southern District and seek a writ of prohibition from the Southern District on the basis that the immunity question is a federal issue. It's a presidential immunity. It doesn't exist outside, the scope of the Constitution and the office of POTUS. So it's a federal right that he is entitled to assert. And so principles of federalism would support, not federalism, supremacy principles would support the district court from issuing a writ of prohibition to Marchand. Now, let's say all of that happens. I still expect Marchand to issue a sentence
Well,
in
this is
absentia.
what I was going to ask you both on. Do you think that there will be a hearing on Friday or not in front of Judge Marchand? Yes or no?
Yes, unless he is enjoined or stayed
By the Court
by
of
a
Appeals.
court of appeals
Yeah.
or federal court of some.
I think he'll hold the hearing anyway.
Oh, you don't think he'll hold a hearing in the face of an
Sure.
order from the appellate division?
He can walk out on his bench and say, "This is the time I set for a sentencing hearing," and then he can just speechify
Yeah.
from the bench
But do you really think he'll
and
do that
say,
if the appellate division says his case is stayed?
"What's he got to fear?"
Well, the Court of Appeals might decide to say he's in contempt. I don't think
Well,
he'll
they
do
could have
that.
said that. They could have said that a dozen times already, and they haven't.
Yeah. Well, what's astonishing to me is we've seen this rodeo before, right, in front of Judge Chutkan, where Trump's lawyers took that immunity appeal, and then she continued to proceed as if she still had jurisdiction over the case and could do stuff. And Trump's lawyers had to file a motion with her, reminding her that you don't have jurisdiction, Tanya. You can't be doing any of that. And she didn't agree with that in the circuit. Well, she ultimately did agree that she didn't have some jurisdiction and some other, and the circuit had to yeah, tell her yeah. So it's just astonishing to me. These judges know what the law is. It's so unacceptable that in this particular case, they just decide to ignore the law, that any experienced lawyer would be able to tell you that that's what the law is. I don't know how they can look themselves in the mirror. I really don't. So, okay, but what do we think the a court of appeals in New York will stay? Will they say, "Yeah, you're automatically stayed, Juan, because this guy filed a notice of appeal"? Okay?
Let me.
I just don't. I mean, I don't know New York State
Yeah.
procedural law at all to you know what it is exactly, how the appellate court would respond, what the format of the response would be.
Right. Well, Todd
The issue.
Blanche in his papers, he seems to think that that is the New York law, that the notice of the appeal automatically stayed the case, except possibly for ancillary matters. He put that in his pleading. So, because I'm with you, I'm not up on the specifics of the New York law, but Blanche obviously is. And he told Marchand that's what the law is.
The issue is this an automatic
Right.
loss of
That's
jurisdiction?
that's the point I'm
Is it
making. Yeah. Right. Blanche seems
is
to
it
think yes.
or, or is it discretionary? Discretionary would suggest that the judge can weigh the merits one side or the other and go ahead. And if the I can see the New York courts leaning towards discretionary as opposed to automatic. Federal, it's pretty clear automatic. So I think if Trump really wants to stop the Friday sentencing, he's probably going to have to go to federal court.
Really.
Yes, yeah, I have no confidence
In the appellate division? Well,
in the appellate division in New York
yeah.
on this issue.
I don't agree with
Uh,
that. They've done pretty well for Trump on in other matters, so they're more removed from it. I fully expect them to issue the stay. They haven't done that yet, but they're probably waiting for Alvin Bragg's office to file something tomorrow, right? Like they have until Friday or Thursday at least to decide what to do.
they've got to decide the overriding issue, which is does the judge have any discretion or is it automatic? And it's rare that an appellate court will will make a black letter law that says the trial judge has no discretion. That's a rare event, and I'm not sure a state court, trial or appellate court, is going to lean towards automatic.
Well, I don't think I agree with that, King, because of the point Ship was just making, which is because this is something we all learned in law school. Only one court can have jurisdiction of a case at one time. That's why the law is like that in the federal courts. And as I said, in Blanche's pleading, he cites New York cases to that effect, that it's the same there. That once you file your notice of appeal on a proper appellate issue, that's it. The trial court has to wait for the case to come back from the appellate division.
But the issue is this a proper appellate
Yeah.
issue in New York?
Well, see, and interestingly on that, where what I was talking about with this, what can be interlocutory appeal and what not, no court has said to this day, including in Trump's case in the federal courts, that immunity can be appealed interlocutory, right? I thought they would say that in the Supreme Court case, but they didn't. And what's interesting about that is two things. One, Trump, in the Trump case, the US government did not argue, they did not challenge the interlocutory appeal. And when they were questioned about that, I forget by which justice, Sotomayor maybe, or Ketanji Brown Jackson perhaps. Ship, do you remember which one it was? One of the female justices, I think, asked the government, why didn't you challenge this as not properly being part an interlocutory appeal? And the Solicitor General basically said they didn't see any value in that. So without saying so,
Well,
it appears to me
but I
everyone
think,
agrees that you can appeal it.
well, I think part of the issue there was the concession made by Dreeben and the argument that there are some issues of presidential immunity. The question was the scope.
Right, but I'm talking about the issue of whether you can appeal that on an interlocutory basis. The Supremes seem to just assume that you could. No one ever actually
Well,
briefed
no,
that.
no, well, I understand that, but if you're going to concede that there is some immunity, and the appeals court and the trial judge said there's no immunity. To say that, well, the case should have gone forward anyway, not been appealed on an interlocutory basis. Now you're starting to wander into legal absurdity.
Yeah, but my point is the government could have had as its first line of defense in Trump's case that the interlocutory appeal wasn't proper. They
But
didn't, they
how does
waived
that
that
play out?
argument. They waived it.
Well, hold on. How does that play out? You say so. Counsel, your argument is that it's not there's not an interlocutor there's not a right to interlocutory appeal the denial of immunity categorically, but you disagree with the denial of immunity categorically. You understand that the judges were wrong below,
Yeah, but there's lots of things where you could
but there
say the
shouldn't.
judges were wrong below. That doesn't mean you have a right to interlocutory
Well, but
appeal at pre-trial.
well, I understand that, but immunity is the right to be free from the
Oh, okay, but
process.
that's why it is interlocutory. There's two different things, right? So, what I just found fascinating was that they didn't challenge that at all. They could have, but they chose not to. And then Dreeben was kind of embarrassed when he got asked this question by one of the justices, and he gave this kind of non-answer answer by saying, "Well, we didn't think that this was the time to raise that or whatever." Yeah, because you were going to lose that argument. Because if pressed on it, the Supreme Court would certainly say that the immunity issue can be appealed on an interlocutory basis. If they didn't think so, they wouldn't have taken that case and ruled on it the way that they did. So it's kind of a ruling without a specific express ruling. See what I'm saying? I mean, are you under any doubt at this point that you can appeal interlocutory a question of presidential immunity?
It depends on jurisdiction. I think state judges, uh, particularly elected state judges, are their own persons.
Yeah,
And
but I'm talking about what the law actually is, okay? No
I'm
judge
but
in this country should think that the law is anything other than the president can appeal immunity issues on an interlocutory basis.
uh, I can guarantee you there are state judges in this country who believe that the right of appeal is not absolute before a final judgment. And
On any issue,
it's
or you
it
just talk about
on
the
any
yeah, okay.
issue,
But
and that it's the the allowance of such an appeal is depends on the weighing the pros and cons. We'll let some be appealed, but we it's not automatic. That's and in this case, you will have a final judgment that is clearly appealable after
on
Friday.
Friday, right, exactly.
On
So you're
Friday.
talking about the
So let's
difference of
wait a
3
few
days.
days
Yeah.
and let's wait a few days and then take and then we don't have to reach the issue of whether this is an automatic appeal or uh, a discretionary interlocutory appeal. We'll wait till Friday when there's no question it's
Well,
appealable.
interestingly,
Let's
Marchand, in his order, he ignored the question of whether it is automatically a stay, right? Whether the immunity issue can be appealed interlocutory and gives you an automatic stay. Well, and so he goes on to analyze what you're talking about, which is he weighed the factors and said, I'm not going to grant the stay. But I don't give a good goddamn what he thinks about those factors. He's as wrong as Tanya Chutkin was. Once Trump's lawyers filed their notice of appeal in the Court of Appeals, he lost jurisdiction. And I fully expect the appellate courts to tell him so.
uh, I'm not holding my breath.
Well, I mean, that's ultimately what happened in the DC case. And I don't see how it's going to be any different in New York because that's what the law is. Because it's a baseline bedrock principle of the legal functioning of the system that, as Ship said, only one court can have control of a case at a time. So, I fully expect the New York appellate courts to do the right thing there and issue the stay, or say the stay was in effect as soon as Trump filed his notice of appeal. Now, King, you're certainly right. They could, of course, do something different. But, if we're talking about what the law is and how judges should rule on things, if they're following the law, that is what should happen. An order should issue from the New York Appellate Division this week postponing that sentencing while they can.
I thought you were I thought you were asking for a prediction
Ah.
as opposed to a pronouncement as to what the law is.
No,
I agree
yeah,
with you
what the
on the
law actually
law,
is, right?
but
Exactly. Yeah.
yeah,
So okay, so King, what's your view? Is there going to be a sentencing on Friday or not?
I think there will be unless another court tells him
Right,
stop.
right. That seems to be what Marchand thinks. Chip, you agree with that?
Yeah, yeah. I mean, I think Marchand will have a hearing either way, but I think I don't think I don't think for a minute that Trump is going to
Oh
show up.
no, I agree. Well, and if the Court of Appeals postpones it, then he wouldn't be obliged to. But you know, I'm not sure I would show up at that, given what I think the law is. That once my lawyers filed my notice of appeal, Marchand can kiss my ass. He doesn't have any jurisdiction over me. I would not show up for
Uh,
it.
the president of the United States, as of Monday, is going to dare this New York trial judge to hold him in contempt, and then it's like, okay,
Right.
see this. See this little office I got down the road here
Yeah.
called the Department of Justice that
Right.
deals with interference with the
Yeah.
obstructing the functioning of
Yeah.
government. They might have a word with
Well,
you.
it's 2 weeks, right? Because today is only the 5th or the
Oh, the
6th.
10th, that's right. The 10th. Yeah, yeah. I'm thinking about the following
Yeah,
week.
it's 2 weeks.
Yeah, right.
So,
The 20th,
all
right.
right. So we all agree, don't
But
we, that Trump certainly has immunity again once January 20th comes. Even Marchand seems to agree with that, right?
yes, he agrees. Uh, what that means, the problem that Marchand doesn't address is if he goes through with the sentencing that he clearly is aims to
Uh-huh.
do. Uh, what that does is it triggers Trump's right of
Right.
appeal, and then that appeal happens during the term of his term of office as
All right. So
president.
let me ask you guys this, because that raises a question I wanted to get your opinions on. Aren't the appellate cases going to go forward anyway with Trump being president in these various cases?
Well, that's Trump's argument that
Hmm.
it shouldn't because the case should be dismissed before he takes office. There should be no appeal. There should be no outstanding final judgment or
Yeah, and then he appealed today. So,
yeah, but he's asking for a dismissal pre uh, January 20. He wants the case to be dismissed,
right,
and he said this sentence followed by an appeal basically cannot happen under my immunity as president.
right. But it's kind of crazy because in order to get that ruling, you have to be in the appellate court making the argument, right? So, as a practical matter, the cases are going to continue post January 20 for him to get what he wants, right?
Will it? Can he get expedited consideration?
I don't know. And Blanche is filing today, and this is, again, sort of a peculiar New York thing. The first page of it actually says that they're setting the writ of prohibition term, is what the New Yorkers call it, for January 27th or a date thereafter. So it looks to me like they have kind of a calendar control process there. And so they had to pick the first available date from the clerk's office or something. But you would certainly expect that, I mean, they want a ruling out of that division, appellate division, before Friday, right? Or Ship is right. Marchand definitely will hold a hearing. So
They need a ruling, at least a order of stay
Right.
before Friday and a final ruling before January 20th.
All right. Do you think they'll get that second part? Because I'm very dubious about that. That they're going to brief all
Yeah,
this and rule on it before he takes office.
I'm dubious, but
Yeah.
they're going to try, I
Yeah.
think.
Ship, what do you think of that? Do you think the court will accommodate that?
Look, again, I'm just not. I'm the skunk at the picnic here. I don't think there's any judicial integrity at work here on anybody's part. I think it's all just down to real politic at this point. It's like, it would really be nice if three judges would step forward and say enough.
Right.
Enough. Let's all concede reality here and put an end to this. Let's put it on ice. Let's let the man be sworn in, and then the lawyers between Trump's defense counsel and the DA's office can work out a deal that the judge will rubber stamp as to what happens in this case.
After he leaves office again? I mean, Trump and his
Potentially.
lawyers seem hard over on the idea. I'm with King on this, that nothing can happen in any court once he's president.
No, I don't disagree with that. The question is, okay, but you've got a pending case. So what happens to the pending case? Does it remain pending,
Right.
or does it take some other status? Let's sort that out. Everybody agree we're not going to have a sentencing, we're not going to have appeals, but we got to decide what to do with it.
Right. That's why his lawyers are pushing so hard on the dismissal, right? Because they're trying to maneuver everyone into seeing that that's the inevitable result. You might as well do it. And what I find interesting as a lawyer is that that's not actually a legal argument. That's not a legal basis for dismissing the indictment. The fact that it's tainted with the immunity is the legal basis for dismissing the indictment. But well, he got elected president in the meanwhile, and so we really just can't go forward on this. I'm not persuaded by that at all.
I disagree. I think that's a strong argument that a dismissal is mandated once he takes office, and they're arguing it should happen now because he's in the transition process. Uh, but either one way or the other, I think the argument that nothing can happen after he is sworn in uh, is a damn strong argument because if you try to keep anything alive, whether it by appeal or by abeyance of the sentencing, you run afoul of the whole principle underlying uh, the immunity afforded a sitting president from criminal prosecution. You tie him up, you subject him to uh, possibility or the threat of future adverse consequences. Uh, you it the supremacy clause kind of knocks the state the legs of the state out from under New York if they try to do that.
And see, I agree with that in this up to the point of saying they can't do anything to him, but I don't think that's a basis for dismissing a pending case. Certainly not one where the jury has rendered a verdict. That doesn't make any sense to me at all. And I'm not persuaded by this. He's got the special status as president elect or under the Transition Act. I think those arguments are wrong. Um, so you got until January 20th, if you see the law the way I do, to do something or not do something. Um,
Now, Leslie, I have an aside here.
Go ahead.
I took Mrs. King out to dinner tonight.
Oh, nice.
I had 2 glasses of wine. And as we were leaving the restaurant, we walked past the door into the open bar next to the restaurant, and it was about 2/3 full. And it was nice and warm and cozy looking in there.
Yeah.
And we were about to step outside into the freezing
Oh,
cold.
no.
And it just occurred to me that what a great moment to have a CNN style New Year's Eve soiree with me on the spaces here,
Uh-huh.
having my drinks at the bar with the noise in the background and all. Wouldn't that have been cool? We could have really had a great
No, I would have
argument.
had to have muted you because nobody would have been able to hear a thing you were saying. So, well, okay. So we think on our title here, we've got right, wrong, or will it happen? So, for Judge Marchand's sentencing on January 10th. So we're sort of split, it seems like, on whether we think he made the right rulings about dismissing the case because of the transition. I think we're all in agreement, correct me if I'm wrong, you guys, if that Marchand should have dismissed, it should have vacated the conviction and he either ordered a new trial or dismissed the case because of the immunity. So it's kind of like he was right and wrong. And we think there will be no hearing on Friday unless Marchand decides to hold one anyway. Is that where we are? So that's clear as mud.
That's
Yeah.
about what I've got. Yeah, I need to jump off
All
here.
right. Good luck tomorrow,
I gotta
Ship.
get back to work.
Yeah.
All right.
See ya.
Talk to you later. See
Okay.
everybody.
Good night.
Good night. All right, King. So, you know, it's just still does not cease to amaze me that judges cannot grasp legal conclusions that, if you were in a room full of lawyers just kicking it around, 90% of the lawyers would, see it one way, and then the judges are like pretending like that law is somehow new news to them.
Well, this judge has been political and biased from the
And
start.
that's why it's the
And
same as Judge Chutkin, because it's the same thing, right? It's that they don't want that to be the case. They don't want to be deprived of jurisdiction over this case, so therefore they conclude they're not. This is really not the way judges are supposed to function.
but they exist. He's not the only one
Yeah,
in the country
yeah,
that acts like this,
yeah,
and I'm not optimistic that the uh, appellate division in New York will be any different.
yeah. I have higher hopes for them than you guys do. They've not done a bad job on um, their analysis on Trump's other cases. They haven't issued some of their rulings on that yet, but they have a better track record of like actually applying the law instead of suffering from Trump derangement syndrome. So hopefully they'll do the right thing. Now, on
Yeah,
your point about,
just
go ahead.
yeah, just so everybody understands. Big picture. If Judge Merchant goes forward and gives Trump a sentence of you don't have to pay any money, you're not on probation, we're not putting the leg irons on you, we're not uh, making you report, no fine, no jail term, you're done. This case is over, but you're guilty. Uh, that's your sentence. That will be appealed,
Right, and Trump will appeal. Right, he's not going to not
and he
appeal.
will win it. He will win
Yeah, he
it.
will.
That will be reversed.
Yeah,
Whatever Judge Merchant does will be reversed,
right. Eventually.
and he may know that actually,
Right.
and doesn't care.
Right. Which leads us to the strategy issue I wanted to talk about. And you kind of alluded to it earlier, which is a different way to go for a different client on these facts would be suck it up, go to the hearing on Friday. He's not going to do anything to you. His bark is going to be worse than his bite. You have to sit there and listen to him flap his gums for half an hour or an hour. And then, case over, we're done. We're going to appeal anyway because he's already made his ruling on the immunity issue and he's wrong. And we're going to go to the courts of appeals. And that appeal is going to happen no matter what, right? So why not just get it over with? Definitely have a final judgment, take the case out of Marchand's hand, and talk to the Court of Appeals. But for a regular client, that's probably what you would advocate doing. But for this client, it's obviously not going that way. And I think, don't you, for the reason you identified, which is Trump is more concerned about sort of the legacy, the reputation. If he can get the courts of appeals to undo the jury verdict prior to the sentencing, he would prefer that.
I've had clients who were willing to go to the mat
Right.
for that kind of reputational interest. And this is that type of
Right.
case where he is right in the law. The procedure used against him violated his due process, and even though it's really not even a slap on the wrist he will get, he, uh, he will be forever tarred with that uh, uh, label, which is he was found guilty and sentenced
Right.
for 34
Right.
felonies, and which helped him steal an election. That is, uh, again, he's going to go to the mat on that.
Right. Well, he has signaled that he's going to, and I think he will. As a practical matter, most clients fold in the face of principles versus practicality. But he is the kind of client who doesn't. So, but I was interested once that ruling came out on Friday to see which way was it going to go because, could have gone the other way too. Because as a practical matter, as you were just saying, you're ended up the same place, right? You're going to go to the courts of appeals and they're going to throw it out. It doesn't matter that Marchand gives you your little fake sentencing hearing and says you're unconditionally discharged or not, really, from a legal perspective.
Yes, one way or the other, the appellate court will look at it. If he loses there, he's got a federal avenue.
Right.
Uh, so I we'll just have to see whether somebody
Tells
uh,
Marchand
has
to sit
tells
down.
Bershad, yes, yeah, stop it.
Just stop. Just stop. Oh my. Well, okay. And then the we're going to talk not next time because next time we're going to talk about the TikTok case. But after the TikTok argument on Friday, uh, we're going to do, before the inauguration, a little review of where all the cases, Trump's cases, stand and kind of say for people, explain to them, this one's dead, this one's not dead, this one might be dead, for people keeping score at home. But in terms of your removal case that you're bringing up, the docket shows that the government's brief is due a week from today on the 13th. And so that court, which is the federal appeals court, the Second Circuit, they're not going to get around to ruling on that removal until sometime later this spring, this summer, this fall, depending upon when they hear the oral argument. So I'll be fascinated to see, is are Trump's lawyers going to say that case has to stop because he's now the president of the United States and nobody can do anything? What do you think about that?
I think it does have to stop, but in the meantime, he may ask that court uh, to enjoin uh, Judge Merchant. They the Federal Anti-Injunction Act applies if you ask a federal court to issue an injunction against a state court to stop some case before it's final. And usually the general rule is federal courts are not allowed by
To do
law
that, right?
to do that.
Right.
One exception is where they have to preserve their own jurisdiction, and that applies here.
Right. To the
If
removal
if Judge
statute.
if
Yeah.
if Judge Merchant rules and finishes the
And
case
tries to enter
on
an
Friday,
order. Yeah. Right.
yeah, it deprives the Second Circuit of their
Right.
jurisdiction.
So he may hear from them on Friday too.
Correct.
So we'll keep an eye on this, you guys, to see who does what. And it's going to be interesting. I fully expect Alvin Bragg to file something tomorrow, probably, or maybe Wednesday. Um, I don't think the appellate division will hold a hearing. Do you, King? They'll probably just issue an order telling Marchand stop or don't stop.
That'd be my guess.
Yeah.
Yes.
So that may not come until could be even Thursday. So we'll see. All right. Well, King, I hope you had a nice evening with Mrs. King. You got anything else you want to say before we sign off tonight?
No, it. I had a delightful evening with Mrs. King.
Mm.
Uh, Despite the fact that I don't have hot water on part of my.
Hot water heater still isn't installed?
It's being installed. A new one is installed tomorrow.
Tomorrow. Okay.
Tomorrow, so a cold shower. I
Oh
guess
no.
never hurt anybody. It's
Uh,
invigorating. I'll say that.
yeah.
But it would have been nice to have my post New Year's Eve soiree
Mm,
on a Spaces chat
yeah.
in a cozy bar.
Yeah. That would have been sweet. You should have taken a hotel room, taken Mrs. King out for the full treatment.
I Yeah.
If that water heater doesn't show up tomorrow, that's definitely what you should do. Take my word for it.
That's all I got.
On that note, we'll say goodnight. Good night, everyone.
Good night, all.
He said he thought he would be able to join us. I just sent him a message. So, as you know, he's in trial this week. Oh, and there he is. But they have, I'm going to send him a co host invite. Ship, I'm sending that to you now. So, but there's, the courthouse is closed tomorrow for the funeral of the former President Carter. So, you have a day off tomorrow, right, Ship?
Yep. But right now, I'm just sort of going to stay awake.
It's a dead president's holiday.
Yeah, yeah. So, well, yeah, because after a trial, I don't know if you guys know this, but after when you're in trial, if you get a break like this or the day that it ends, you have a huge adrenaline low, right? Like you just crash. So, but you got to go again on Friday, Ship?
Yeah.
Yeah.
And
Okay.
then, I was about to go to sleep, and then I suddenly sat up like a bolt in the hotel room bed and thought, oh no, I've got to do the spaces.
Right. I told Leslie I would do the spaces. Oh no. Okay.
Ship,
So,
Ship, you're my hero.
he's a hardworking man. Well, I suspect, Ship, that you function on less sleep than I do. This has always been a problem for me as a lawyer, that I need 9 hours of sleep every day, or I'm just a hurting puppy. Susie likes that. Hey, Susie.
Started at 4 a.m. this morning.
Oh my God. Are you normally like a 7 hour sleep only guy?
I've gotten to like 5.
Oh my God.
What's Steve get?
I remember trials where I would average 2.5 to
Oh yeah,
three
no. In
to
trial,
three
I've worked
for
48 hours straight. Trial is one thing, but for normal though, Steve gets about what? About 6.5, 7 hours of sleep at the most every night, and that's all he needs to function. What about you, Ship?
I'm usually up by 5 a.m., so
Yeah, he's an
I'm
early riser
lucky if I get
too.
6.
Yeah, he's an early riser too. Not quite that early, but how about you, King? Do you need more sleep than most, or
no, average 6.5
yeah, women?
probably.
Yeah, women need
But
more sleep than men. Did you guys know that? As a
I did not know that.
biologically, that's true. So.
Uh,
Okay. Well, so I know some people who aren't sleeping tonight much. All these lawyers working on their pleadings that are all due by 10 a.m. tomorrow morning. They're not getting any sleep. So, as of 8 o'clock tonight, here's the status in terms of Trump's effort to not have a sentencing proceeding on a Friday morning. So, less than 2 days from now. Excuse me. I still have my cough, as you guys can see. So the status is this: Trump's lawyers filed this morning in the Supreme Court asking for a stay. Interestingly, they didn't say what rule they were proceeding under. The rule in the Supreme Court rules for stays is Rule 23. I posted that on my Twitter earlier today. You can see if you read it, it gives them extremely broad discretion. It literally says in extraordinary circumstances, you don't even have to have asked for relief from the court below, and they can still still rule on it. So they've given themselves vast power in this area, technically, which they seldom exercise, but that's what the rule permits. So interestingly, Trump's lawyers filed in the Supreme Court this morning, but they didn't file in the New York Court of Appeals, which is New York's highest court, until this afternoon. But they did get on file in that court as well. They told the Supremes in a footnote that they were going to be filing in the New York Court of Appeals today. King, I was never able to get onto that docket. It looks to me like the criminal docket in the New York Court of Appeals is not publicly available until they actually render decisions. So, presumably, they either gave Bragg time to file or he told them he was going to file. Do we agree on that?
Yeah, I've had the same problem
Yeah.
getting into there, but uh, what they filed in the Supreme Court was pretty strong, I
Yeah, it was
thought.
pretty good. Yeah. So I'm going to talk about that in a second, but let me lay out the procedure first. So they filed in both courts today. This morning, in response to that filing, Justice Sotomayor, who's the justice who sits over the Second Circuit, told Bragg to file his pleading by 10 tomorrow morning. So I don't think the Supremes plan to do anything today, and they're also probably going to wait to see what the New York Court of Appeals does. But
Let me, let me ask
presumably
a
New
question.
York's going to give Bragg time to file something too, right?
Let me ask a question.
Yeah.
So, I think I just glanced at the brief in the Supreme Court. It's 62 pages long, right?
Yeah.
And they went straight to the Supreme Court. They didn't go through any lower courts, other lower federal court.
Right. They jumped from the New York Intermediate Appellate Court, which is called the Appellate Division.
Right, and that order denying the stay came down yesterday.
Right. Now, interestingly, when the Supreme Court folks opened the docket this morning, they put that the lower court was New York's highest court, and then they changed that about lunchtime because the order that is currently the one that's in existence is from the Intermediate Appellate Court in New York.
Okay, so in 24 hours, the Trump defense wrote a 62-page brief that King says is very strong and written very well, and Bragg will do the same thing in 24 hours.
Right, one would think. Plus, we're going to talk tonight. They filed in the 11th Circuit a different set of lawyers for Trump.
Or has the Trump defense been working on this for 2 weeks?
You would think they would have to have been at least since Merchand's ruling last Friday, right, where he actually set the sentencing, and
Yeah, and
probably before.
so it looks like they produced a 62-page document very quickly, but I'm sure
Mm.
they've been grinding over this thing for several days, and now Bragg's got less than 24 hours to respond to it.
Right.
Yeah, let me explain the route one ordinarily takes out of state court to get into the Supreme Court. You first you try your case in the state court, lose, appeal to the first level of appellate court in the state, and then if you lose there, the next step is the state highest court. Usually, the state Supreme Court in New York is the New York Court of Appeals. If you lose there, the only place left to go is the U.S. Supreme Court. You rarely are able to jump along the way, jump out of the state proceedings and into federal court. You get to the Supreme Court as the last resort in the
It's the
line.
last thing on that line, right? And in fact, as you were telling us last night, King, or the night before Monday, I guess, for people who weren't on that one, there's actually a federal statute that prohibits, for the most part, federal courts from entering orders, injunctions, telling state courts what to do, to really oversimplify it a lot. um, because on federalism principles that the federal courts have review of what happens in the state courts in some circumstances that's spelled out in the federal rules, in the federal law, from the Supreme Court's opinions. But other than what the Supreme Court, or or the federal statutes or the Constitution say the federal courts can do vis-a-vis state courts, the district courts of the various states, the circuit courts that we talk about all the time that are federal courts, you can't just simply, in the middle of your state court case, apply for a TRO from a district judge to tell the state court judge to stop doing what he's doing. That does not work. So, this is where we are. And so I think in terms of what's going to happen is tomorrow Bragg is presumably going to file in both courts after working overnight, right? And you guys think that he shipped, to your point, do you think that his office has been preparing responsive pleadings? I mean, you're a little bit unable to until you see what the other side says, but you can do some prep, right? Ship. Ship, did we lose
Well,
you?
you can anticipate
Yeah.
where you're going to likely need to go and do your general basic research and start to put together a structure
Yeah.
before you really start hanging the baubles on it. Um, but
But you can
I
never
think
anticipate all the arguments the other side's going to
yeah,
make,
I
really.
think I think they've always I think the Trump defense always had a game plan if they lost right down the line in New York State, and I think this was always the move. Because they haven't got a whole lot of luck in the Southern District of New York with Second Circuit,
Right.
and they already know there's 6 votes sitting there saying, "You morons, the president does have immunity."
Right. Exactly.
Um,
So, all right. So we will definitely see Bragg's pleading in the Supreme Court because their clerk's office is very transparent. Their docket is publicly available. And just on their website, you don't even have to log into the filing system. New York, not so much. So I don't know if we'll get a look at Bragg's pleading tomorrow, but do we think that the Supremes will sit back a bit, wait to see what the New York Court of Appeals does first?
I would guess they would, yes.
Hoping
Unless,
they do the right thing.
yeah, unless the New York court takes too long.
Right.
What's really at issue here is which court has the ball. Is the ball in Judge Merchant's court to finish his sentencing, at which point the normal appeals can then start from Judge Merchant to the intermediate appellate court, which is the Supreme Court Appellate Division, and then from there to the Court of Appeals of New York, and from there to the U.S. Supreme Court. So is the ball in Judge Merchant's, or should it be in Judge Merchant's court, or should the ball be in,
Already.
in this line of appeals? And because these appeals are from Judge Merchant's order uh, a week or so ago denying Trump's motion to dismiss because he screwed up the immunity issue. And
Well, there's
since
technically two orders. So he ruled on that issue that you just mentioned, that Merchan screwed up the trial by injecting immunity issues into it. He ruled on that actually December 16th. What he ruled on last week was the second motion that Trump's lawyers filed, where they asked for the dismissal based on immunity grounds and other grounds, supremacy clause grounds, transition statute, saying that Trump also has immunity based on being the new president elect. So they filed one notice of appeal from both of those orders, but they both involve immunity, right?
Yeah, and so the issue is neither of those uh, appeals are from a final judgment.
Right.
They're what we call interlocutory appeals, appeals in the middle of the case, or appeals before the case is finally over, which will happen Friday. And ordinarily, those are not heard. The appellate courts wait until the thing is final, because we don't want piecemeal appeals. Every time you lose a motion in trial court, the appellate courts don't want to see a new appeal coming up every time somebody loses. They want the whole case to be over so they can hear it all at one time in one place. The DC Circuit, more or less kind of confirmed by the U.S. Supreme Court, have made a massive exception to that, and that is on the issue of immunity. Immunity can and should be a subject to an interlocutory appeal, and Trump's people are arguing that appeal automatically divests the trial court of jurisdiction, and it is automatically stayed. They don't. No further action should be necessary once they take an appeal relating to an immunity decision.
So let me stop you there. That's obviously, I've said many times on Twitter today included, that is what I think the right answer is. That taking that appeal from that order on that ground, on the immunity ground, works to automatic stay because it divests the trial judge of jurisdiction. Do we all three agree on that? Like, that's what the actual law is? Anybody? King?
Well, yeah, yes. Uh, According to the D.C. Federal Circuit, uh, yes, that's what the law is. Uh, there may be some outliers uh, that I'm not aware of, but the one court that has expressly addressed it says just what you said. The trial court is automatically stayed, and jurisdiction now lies in the appellate court to decide the immunity issue.
Right. So why did the New York Appellate Division not say that that was the law yesterday?
Because they're not bound by the DC Circuit. That's why.
Yes, yes, as a technical matter, but we don't really think that that's not the law everywhere, do we? Like that's the only thing that makes sense is that the trial court loses jurisdiction when you note a proper appeal.
The other argument is that it's like other interlocutory appeals. It's discretionary with the appellate court as to whether to enter a stay of the lower court case. Uh, that
That's the way that that judge in New York treated it, the
cor-
one judge who heard it in the
correct,
appellate division.
and that's the general rule, and that's why they did it. They're New York. They're not federal. They're not in D.C. Uh, so they don't think they are bound by it. And so we're going to apply New York law. And New York law says it's up to the appellate court uh, on whether or not to stay the lower court case pending
this, this
appeal,
is this
and,
is
and,
taking
and
me
whether to take the appeal at all.
right. So this is taking me to a question that Steve and I were debating today. So on what basis is there a proper basis for the U.S. Supreme Court, therefore, to get involved at all? Because, as you laid out for the folks so they would understand it, King, you can appeal to the Supreme Court from your state's highest court. It's called a petition, but basically it's an appeal. You can do that, but you still have to have a federal issue that that appeal is based on. You cannot just appeal to the Supreme Court from the highest court of your state on any old thing that you want to. So, the, this is what I was trying to grapple with today. Do we think that it's really a question only of New York State law or even New York State procedure as to whether or not the stay is automatic when the grounds for appeal is immunity?
It shouldn't be, but I think it's sufficiently uncertain, even in the federal system, as to whether it's automatic or not. You have one circuit court that has clearly held that it is
Automatic.
automatic.
Hmm.
The Supreme Court in the Trump immunity case didn't say it expressly, kind of implied that's the way it works, but we haven't had a case.
Right. That's what I keep telling people. There
Mm.
is no decided case from the Supreme Court that says you can appeal an immunity decision interlocutory. There are Supreme Court cases that say that you can appeal interlocutory with a stay. Other kinds of issues in federal criminal cases. The easiest example is the speech and debate clause that protects the members of Congress. So the Supremes didn't come right out and say that in Trump's case, but they didn't that didn't slow them down. They went on ahead and decided it on an interlocutory appeal. So kind of by negative implication, I would interpret that as a practicing lawyer that it's effectively a ruling that that's what the law is. But kingship, do you guys think that's a constitutional rule or is it a procedural rule? Because whether it's constitutional or not, or whether it's procedural, might make a difference as to whether or not the Supremes would hear the case. What do you guys think?
Constitution.
Well,
I
yeah,
think
I think they
Constitution.
have to.
Because it's presidential immunity and it
Right.
Yeah.
would defeat the purpose of it if it isn't.
It only applies to one person, a unique branch of government,
Right.
and it's a
Yeah.
federal officer.
Right.
It's not just a federal officer; it's a constitutional officer.
Right.
Um,
So, but let's circle that back then. So, King's point is, well, the New York courts have decided to apply their own rule. Well, how are you doing that when what we're talking about is this unique federal constitutional actor?
yeah, again, I think so much of this is a question of first impression, and it's simply
Yeah.
whatever the court wants to do ultimately. And
Yeah.
as I told you earlier in a phone call, the easiest dodge in the world is to say we're going to grant an administrative stay while we have the issue briefed, and then on the 21st dismiss the whole thing as moot.
Right. All right. So play that out a little bit so people can understand it. What are you
Okay.
talking about?
An administrative stay is imposed by the court simply to keep everything as is while the briefs are being filed, so that the parties can muster all their arguments in the proper format, so that the court can make best use of them.
Duly
And so,
considerate.
yeah, so sometimes that could be 3 days, it could be 7 days, it can be whatever, and the court would vote on that. Um, and so
But you're talking about the Supreme Court now.
correct, it would be an administrative stay, not targeting the New York proceeding as much as it's just saying nobody's doing anything until your briefs are in. Then we will decide whether to lift the administrative stay and not decide the case, or to decide the case on the merits.
Well,
And
Ship, they could really put their thumb in the eyes of the state court people by saying we're going to have administratively stay everything until briefs are filed and we hear argument on January 21st.
exactly, and then it all just goes away because as of
Right. Thank
January
you for
21st,
playing New York.
yeah,
Goodbye.
yeah. So, and all they really need to beat to make the whole thing evaporate is Friday.
Right.
Once they beat Merchan out of his hearing on Friday with an administrative stay, it's the rest of it all falls away.
Right. Game over. Well, but that's what the Trump lawyers thought they were doing by filing their notice, right? They thought that means automatic stay, which it does. And therefore, there was no way Merchan would be able to sentence before the 21st because meanwhile, the New York courts of appeals would have to figure out the immunity issues. So, all right. Well, what do we think the odds are that the New York Court of Appeals will issue the stay tomorrow?
I'd say 50-50.
50-50. What about you?
Just because, like I said to you on the phone, they don't want to be called chuckleheads by the Supreme Court.
Right, exactly, right. And it's like this is the beauty of the strategy of filing in the Supreme Court first this morning, I think, and then saying, "Oh, by the way, we're also going to file in the New York Court of Appeals." So the Court of Appeals knows they're already on file with the Supremes. So now, do you want to make yourself look stupid, New York Court of Appeals, like the DC Circuit did in several of these cases, or do you want to do the right thing? And then the Supremes won't have to do anything, right?
That argument would apply to a whole lot of things that Judge Merchant did. But he, like a
The
bull in the
chucklehead
china shop,
argument.
he went right ahead.
Yeah. 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 So Ship thinks it's 50-50. The Court of Appeals rule issues the stay tomorrow. King, are you on board with that?
Yeah, I'd say, not knowing the individual characteristics of the judges there,
Yeah. And the makeup of the
and
court. Yep.
uh, unless you have some more bulls in the china shop, I'd
Yeah.
say 50-50 or even better for a stay.
Yeah. And then presumably the Trump people will then notify the Supreme Court that we don't need you to act right now and withdraw the stay or ask for, you know, them to just hold it for a while. um, okay, so people are going to say, well, but then what happens? So let's say,
Before you go there,
go ahead.
Bragg's defense to this is that it's the immunity issue in the Trump uh, New York case is bogus. That everything we're talking about involved not unofficial acts by Trump done in his private capacity.
Well,
And,
I might have agreed with that if Alvin Bragg, had not then injected a bunch of official acts as part of his evidence.
well, but he is. You read his opinion.
Yeah.
The judge said on the surface they may be official acts, but they weren't really. They were Trump defending this case, is what they were. So that's all private and having nothing to do with the public good. This is just Trump being Trump, defending himself personally from these accusations. So I'm going to ignore all that, cut through all that, and none of that had any effect on the jury anyway. He's still guilty. That's
Right.
Bragg's defense is really on the merits.
Right. And Marchand went along with that. He's
Yeah.
basically doing harmless error analysis. So that saying, well, that that bad stuff that, I let in, because it was immune, that didn't really affect the jury because it doesn't overweigh all the evidence that you were oh so guilty. So let me ask you guys this. Based on the Supreme Court's immunity decision, do you think they are going to say that immunity analysis is subject to harmless error analysis?
They would have to rewrite their opinion if they did that. Because they made it clear that analysis must be made before the
Pre-trial. Right.
pretrial,
Right.
and it was not here. You can't do it post trial because if Trump is right, you have defeated the purpose of immunity.
Right. Ship, you agree with that? You think they'll say it's not capable of harmless error analysis?
Yes.
Yeah. And so people
Yeah.
know that would be unusual. There are very few things that the Supreme Court has said are not subject to harmless error analysis.
And I think the message to Marchand would be, well, granted he took the chance of trying the case while Trump versus United States was pending.
Right.
And then the outcome of Trump v. United States undermined the government's case because it includes testimony that runs contrary to the Trump versus United States opinion. but the testimony was already had. The jury had already heard it. They'd already rendered a verdict, so that there was that error couldn't be cured. To now say, okay, so the error that couldn't be cured that took place in a trial that shouldn't have happened is subject to harmless error analysis.
Right. Yeah. Basically, this judge just can't admit that he screwed up.
Right.
So, but that's how he rolls. So, all right. Well, but King, you're right to point out that, all right, well, this is Bragg's argument, right? That Mershon is right, and therefore the immunity isn't a real issue. But that's not an argument that undermines actually Trump's right to have the appellate court decide that.
Well, even more than that, the strength in that brief, I thought, was the focus on all of this argument about whether it was immune or not, and whether it was admissible as uh, non-official act evidence, has to be done pre-trial.
Right.
If you wait until after the trial to decide that issue, you risk, and it's a substantial risk, you risk doing precisely what the immunity concept is meant to avoid, and we cannot allow that. And
Well,
that that
and
that
yep,
is that was the theme, and it was very well done.
right. They're playing into what the Supreme said. And I'm just astonished at some Bragg's counter argument and the argument that the courts seem to be accepting in New York, which is, well, but we had the trial and the trial's over, and all that's left is the sentencing. And so it's like, yeah, you screwed this guy out of his rights to his immunity. And since there's only a little more screwing to be done on that point, we should just keep going because, he's going to get his right of appeal, promptly thereafter. That just astonishes me.
It's a tempting out for an appellate court, though. I'll give Bragg that once Merchant told everybody that I can't tell you what the sentence is going to be, but wink, wink,
Wink, wink.
here it
Here's what it is.
here's what it is, and what it is I'm just dismissing. I'm going to find you a convicted felon and then dismiss the case. I'm not even going to slap your wrist, Mr.
Right,
Trump.
right. But he's gonna like bark at the sentencing hearing itself, right? Ship, have you ever been in a criminal sentencing where the judge didn't scold the defendant? Ship, are you sleeping? Is that snoring?
Who?
You.
No. I was moving.
Uh-huh.
No, I was moving around.
Uh-huh. Did you hear my question?
I was not listening.
You sound like you're sleeping, my friend.
Yeah.
Yeah. All right. So the
Look,
question is, have you ever attended a sentencing, either as a prosecutor or defense lawyer, where the judge did not scold the defendant?
um, it kind of depends on the defendant's attitude. I mean, any defendant that remains somewhat defiant or not properly genuflecting to the authority of the court
Even when
is
they're
going to get.
super remorseful, the judge is like, "Well, but you really shouldn't have done that. I know you're sorry, but I have to say, you really shouldn't have done that."
Well, no, as a general proposition, you're right. But has there been an odd quirk here and there over 35 years? Yeah, there've been a couple of them.
Right. So we totally expect Mershon not to scold him on Friday, right?
If he shows up,
Right. That's another thing I
Uh,
will be
yeah,
in.
yeah. What happens if he doesn't even appear
Right.
remotely?
Right.
well, I don't think there's any chance he's going to appear.
So then
Well,
what
wait,
happens?
wait, wait. Last time he,
Uh,
well,
uh,
wait, the last time he was there, who was he? He wasn't the president-elect. I don't think the Secret Service is going to let him go anywhere near that courthouse.
Well, he's not going to the courthouse anyway. They've already arranged for him to appear virtually from
Oh
wherever
well,
he's
okay,
going to be.
that's true.
But still wonder if he will show up.
I'd still leave it as an empty chair. Talk
It's
to
a
the chair.
dicey proposition. I mean, you've got your lawyers in the courts arguing your legal position. You're respecting the rights or the powers and prerogatives of the third branch, right? But that would
No,
not
no, no,
be
no,
that would
no,
not be if you don't show up
no.
without a stay.
This is the trial court of the state of New York. It is not the third branch.
Well, but in a global sense, it is.
I
But
don't think so. I don't think
I'm
so.
saying his lawyers are in the courts of New York seeking relief for him, and if they don't get it, he's just not going to do it
And
anyway.
what's going to happen? Is Marshawn's going to issue a New York state court bench warrant?
No, but I'm not talking about that. I'm talking about how it looks. I'm talking about.
You're talking about the guy who couldn't
Yeah.
care less about how it looks.
Well, then why are you having your lawyers go through all these machinations to get the stay? If you're just not going to show up, period, then just don't do it. Then say, screw you. I noted my
Well,
appeal. You don't have jurisdiction. I'm not showing up. He wants the imprimatur of saying it's with the higher court's approval that he's not showing up.
If I were advising President Trump,
Yep.
here's what I'd tell him to do. President Trump, you need to make a personal visit to Los Angeles with and
Oh
use your
God.
phone. We can hook you up
Oh
with
my.
a
Flames
virtual
in the
appearance
background.
with the fires in the background,
Oh my
and
God.
you can say, Judge, I'm present, even though I can't be there physically. I'm here where I'm
Right.
needed. That's what I would tell him to do.
Oh my goodness. That's an idea. Well, I think if Trump doesn't get a stay, which I think he will get a stay, but we're being hypothetical here. If he doesn't get a stay, I think he will appear. He won't want to. I mean, he definitely doesn't want to, and I don't blame him. I wouldn't either. And it would be very tempting to be like, screw this judge. I'm just not doing it. But if he doesn't get a stay from the U.S. Supreme Court, and then he's just going to be a law unto himself and not show up, that's not a good look. That's not who he's saying that he is. Do you see what I'm saying?
well, but I think he's been willfully contemptuous of
Well, and
both
rightfully so, of Marshan.
both the criminal case and the civil case.
Yes, yes, in New York. Yes, I agree.
And
But
I think it's almost to go along by participating is in some ways could be seen as a surrender to the lawlessness of Marchand. Whereas if he leaves Marchand sputtering, he gives Marchand a couple of choices: cite him for contempt or
right,
sentence him in an absentia.
right, which is something we don't normally allow. I don't know what the New York law on that is, but yeah, no, but it's a fascinating, mental, intellectual exercise. What would you do if you were him or his lawyers advising him, right? They cannot actually advise him not to appear if there's no stay in place.
No,
On the
no,
other
no.
on the other hand, their position is that the stay automatically went into effect when they filed the notice of appeal. That's
and
what I would tell him.
and that the court is acting lawlessly.
Right, exactly.
The court
So
is
you
acting
have an argument
contrary to
there.
controlling
Right.
legal authority.
Right. So if he were my client, or if it were me, because if it were me, honestly, I would not appear. But I would issue a statement explaining why that is beforehand. And then I agree with you to just tempt Marchand to do what he's going to do. You're going to send
You
New
know
York
where he could
scientists to
go.
come get me? I don't think so.
You know where he could go that would even be better than Los Angeles is Moscow.
Oh, good grief! I thought you were going to say Gaza.
And then invite
It's Jerusalem. Okay.
Zelensky to join him at the Kremlin.
Oh my God. Oh my God. Okay.
I
So, but
got things to do, Juan.
Right, exactly. Important shit is happening. I mean, even the mayor of Los Angeles is like over in Africa or some shit, right? So,
Well,
we
you know what that turns out to be? I just saw this a little while ago. That's a presidential delegation to the swearing in of the new Ghanaian president.
oh, is that what it
And
was?
the
Why she
mayor
was
of
there?
LA, the mayor of LA
Right.
is part of a four-person presidential delegation. Why is
What?
the mayor of LA part of a presidential delegation?
What, going on Biden's behalf? Is that what
Yeah,
it is?
exactly.
Through State Department?
Yep.
Yeah. Okay, well, probably given how it was obvious that this was going to be a problem with these fires, she probably should have backed out of that. But okay. Um, excuse me. All right. Well,
I just on that subject, have 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 the two of you and anybody else listen? Have you guys seen some of the daytime photographs that have
yeah,
come
it's
out of
bad.
there?
It's bad.
I have it. It's horrible.
I mean,
Yeah.
I lived there. I lived where the Wilshire Boulevard and the 405 cross,
Mm,
and just 2 miles north of there, 3 miles north of there is where it got started in some areas, and then Pacific Palisades is just in effect. You take Sunset Boulevard to the ocean.
right.
So you're on, famous Sunset Boulevard heading to the Pacific, and you go right through Pacific Palisades, and it's all gone.
Wow. Did you see Trump's tweet on this today?
I saw the long Gavin Newsom one.
No. Trump said, there's no water in the fire hydrants and there's no money in FEMA. This is what Joe's leaving me. Thanks a lot, Joe. He cracks me up. I mean, it's just nobody nobody comes up with this stuff like he does. Well, okay. So that's a digression. But you guys got anything else you want to say about this stay? We're going to keep an eye on it and I'll tweet about it again tomorrow. But I think it's coming from one court or the other. I cannot imagine that they're actually going to do a hearing on Friday.
Yeah, I
But
think this is one of those where five of the justices get together in a room and say, let's just put a stop to this.
right. Right. Because these you know, lower courts and or New York courts judges can't seem to follow the law with respect to this guy. It's absurd. Although John Roberts has to be just sick about it, right? Why do they have to keep intervening to do the right thing? Because these lower courts are just, as Ship to use your word, just going to act like chuckleheads all the time.
Well,
Well,
the lower court's conduct is so nakedly political that
right,
they force the Supreme Court to be a counterbalance, and then the Supreme Court gets blamed for being
right,
political.
for being political. It's absurd. Well, one judge who's not being a chucklehead is Eileen Cannon. So, you got anything else you guys want to say about New York before we turn to Florida and the 11th Circuit and the special counsel's report?
Nope. Let's get to Judge Cannon. That's fascinating.
Right. Okay. So, Jack Smith, who still thinks he's acting like the special counsel, although in one of the pleadings, the Trump uh, team slash the other two defendants, um, and these lawyers are very good lawyers. These are lawyers are friends of the crew here. So, Ship, you're very good friends with Stanley, right? Woodward. And one of the other lawyers, John Irving, was a longtime partner at Steve's law firm. He's a good guy. We know him very well. And so their pleadings are excellent in the 11th Circuit. So Smith has finalized his report and sent it to Garland. And Merrick Garland is saying that through the pleading that they filed with the 11th Circuit today, saying that they want to release part of the report publicly and part of it, get this, just to the Congress, just to the ranking members of the of Congress, I guess on the Judiciary Committee. And volume one apparently has to do with the DC case where Smith charged Trump and others as unindicted co conspirators with trying to steal the election in 2020, various other things, in front of Judge Chutkin. That case, as we all know, has been dismissed. And so that's, I guess, final. King, we're going to get to your question about that. And so Garland wants to release that part, volume one, about that case to the public with probably redactions for, certain kinds of things, grand jury information and other things. And then volume two is the part that actually relates to the classified documents case in Mar-a-Lago. that was before Judge Cannon in Florida. And that case is on appeal because, as we all know, she ruled that Jack Smith was not properly appointed. Now, meanwhile, the government has dismissed that case as to Trump, but not as to the other two defendants. So now Garland wants to release this report, and he was initially, I think, going to release the whole thing publicly, again, subject to redactions for 6E, so forth. And these two defendants, rightfully so, said, "Excuse us, time out. You can't just release into the public these reports that are saying that we're oh so guilty. We're still on trial here. You didn't dismiss as to us." It's just a blatant due process violation. And so Judge Cannon, yesterday, I think it was, issued a temporary order enjoining the Department of Justice and Garland from releasing the report, Volume 2, that applies to her case, kind of on a temporary basis pending the 11th Circuit's ruling on this same issue. So these two defendants had filed a similar motion in the 11th Circuit, again asking for the court to enjoin the government from releasing this. DOJ responded to that today, and the defense wanted to file their reply tomorrow, but the court ordered them to file it by 5 o'clock today, which they did. So at this point, Garland has had to walk it back a bit. He is saying that he only wants to release not volume 2 to the public, but only to certain high ranking members of the, I think, Judiciary Committee in the Congress. And did you guys see any of these pleadings?
I did not, but I need a program to understand who the players are because
Right.
in the 11th Circuit, isn't it the case that Trump was dismissed from that appeal
Yes.
when when Jack Smith? This is after Judge Cannon held Jack Smith had no authority.
Right.
Jack Smith, without authority, dismissed Trump from the case, and
After
then
Trump won the election. Right.
referred that case to the U.S. Attorney in the Southern District of Florida. So, who is it that's speaking on behalf of Garland in Judge Cannon's court and in the 11th Circuit?
Right. I think it's the, I didn't look at the signature line on the brief, but I think it is the U.S. Attorney or somebody else at DOJ, not Smith himself, because the the defense in that case don't seem to be making a big deal about that, but they are saying, how in the hell is Jack Smith even writing a final report and giving it to Garland to do stuff with when he's been found by a court not to be properly appointed and never sought a stay of that order, and meanwhile has, dismissed Trump out of it. And so that doesn't mean the investigation is over. It just means Smith's not supposed to be doing it. So their whole brief is hilarious because it's like this guy who's not properly appointed and has been thrown off the case shouldn't be doing any of this, and wouldn't even be a report with all this stuff in it that you can't release against us because the court is supposed to be in charge of 6E, because we're still on trial, by the way. None of that would even be happening if all this unconstitutional stuff hadn't started to begin with. It's
Okay,
just so,
okay, and there's a second part to my.
yeah.
Uh, I want to see the
Question.
program. Who are the
Yeah.
players?
Right.
The DC case, Smith was still in, despite Judge Cannon's order.
Right, because they were pretending like that only applied it in her courtroom.
They
Yep.
pretended like it only applied in her court. But you read her order from yesterday, uh, enjoining
Mm-hmm.
the DOJ from releasing any of Smith's report. It does not say any of his volume 1 or 2 report relating to Florida. It says any of his final report.
Right.
So that order applies to both cases on its
It,
face.
you would think it does because they're a part. We had this discussion before because DOJ is a party in front of her, right? She can enjoin them directly. Um, but everyone seems to be ignoring whether or not she has the authority to do that because they're just going to wait to see what the circuit is going to do. So that got briefed as of 5 today, and I suspect we might get a ruling on that from the circuit pretty quick. But the
have the moving parties, your buddies, have they taken a position as to how broad Judge Cannon's order is? Does it apply to Smith in his capacity as the lead attorney in the DC case also?
not vis-a-vis the DC case, but they kind of do because they say this guy's been adjudged to have been improperly appointed and didn't seek a stay of that. So how is he even writing this report, much less it's getting released? Now, of course, it's not Smith releasing it, it's Garland. They really hammer the government with the reg. The reg says that Garland is supposed to notify the Congress when a special counsel is appointed. I think when one um, ceases to function and when the investigation is concluded. And they're like, none of those have even happened. Well, they did notify the Congress when Smith was appointed, but that's not what this is. On what basis is Garland releasing this to the Congress? And they're really unimpressed with the argument that, oh, don't worry about it, it won't get leaked from the Congress.
Well, there is the CFR, the regulation, which is a regulation, and I can repeatedly have to explain this to people on X that a regulation is not a statute.
Right.
It's an internal operating issue.
Rule. Right.
There is a regulation that talks about or says that the Attorney General shall report certain decision making to the chairman and ranking member of the Judiciary Committee. So that is in one of the subchapters of 28 CFR 600. And then the report is contemplated by the regulations, a confidential report by the special counsel to the Attorney General.
Yeah, but that's my point. The regulation says they're supposed to make this notification to the chairman and the ranking member upon appointment of the special counsel. That's not what this is. Upon removing any special counsel. That's not what this is. And upon conclusion of the special counsel's investigation. And that's not what this is either because they're still on trial.
Well, correct. And I think they're trying to maneuver around that by saying, well, we won't include anything about those two in
Right.
In what we choose to release. But these have become, the way the regulation is written has become secondary to the idea that this is just the end run around either a non-prosecutable case or in this case a case that was filed that was shortcut or short-circuited by the election. By producing this, one-sided,
right.
titillating,
Damning. Right. Yeah. Right.
Yeah, a screed. It's a prosecutorial screed.
Right. So
that's
in the reply, they say, in response to all this stuff that DOJ is trying to limit it and do all these limitations, then the defense lawyers say, well, this just argues for a hearing in front of Judge Cannon because you've now raised all these factual issues. Who's it going to get released to? What conditions are going to be imposed? We don't agree with your grand jury redactions. We're just supposed to take the government's word for it that volume 1 doesn't apply to our client, and we might not have the same kind of due process problems with that because they have not been given access to volume 1.
And remember now let's juxtapose this against the controversy over the Mueller report.
Right.
And the big difference is obviously with Trump having appointed Bill Barr to be the Attorney General, that changed the dynamic with Mueller and his report because Barr held the report for 2 weeks before it was disclosed to the public to vet it himself for inappropriate 6E material or whatever. Now you have a situation where the special counsel and the attorney general are politically aligned,
Right.
which just creates the incentive, the political incentive, to write as tilted a version as is conceivably able to be done.
Well, and there was nobody on trial when Mueller's report got released. They passed on charges,
Right, right.
right? Same thing with her. Same thing with Durham, right? None of that happened until all the cases were actually concluded. Here, these guys are right. They're still on trial, right?
Well, I
So,
heard some time ago, Andy McCarthy gave, a great explanation for why, you just cannot have a document come out like this that is that carries in any kind of imprimatur of being fair, because the indictment is written. And so
right,
what Smith is going to do is he's going to essentially produce, what he produced in court, which
right.
was, here's everything that I would prove my indictment with. And as McCarthy pointed out, the indictment says that all of these figures in the Trump administration and in the Trump campaign in 2020 told him he lost. So he knew
Right.
he lost. But what is left out of the story is that in a trial, Trump would put on witnesses to say, we told him he won.
Right.
He was
Right.
getting conflicting information
Not only
because,
that, not only that, but every single witness who says he lost would be challenged on cross examination.
yes,
Right.
yes.
What is the foundation for that? Are there, did you do an independent investigation, and what did you look at? What evidence do you have to support that conclusion? Those are
Right.
just
Or is
either
that just your opinion? We
is
were
that
talking
just
about this.
is that
Right.
pure speculation?
Right.
Uh, it
55 people's opinion doesn't make something true.
doesn't
Right.
make it admissible.
Right. Exactly. So these lawyers, they do a great job. They point out, get this, that the government is the one that wants the hurry up here, and we all know why that is, right? But they say the attorney general is an office, not an individual. It continues. They're the only ones that are asking for the hurry up here, and they say, quote, the urgency of political activity is a fake urgency.
You've got
So
another
there,
lurking problem is that while these two remaining defendants in Florida have an immediate due process issue,
yeah,
uh,
right.
the DC case has been dismissed without prejudice. What happens if a Democrat gets elected the next president
And
and
wants
wants
to
to
revive that
revive that
case,
case?
right?
You have a due process issue there.
Right. Against Trump and whoever else they might indict or blast as unindicted co
Are you telling
conspirators.
me that the jurors of the District of Columbia will be prejudiced by the exposure to this information? They
Oh
they
my
they
God.
will no longer be able to be unbiased and impartial.
Unbiased. Or, well, I mean, they're going to tell the judges that they will be. So what's your problem? Yeah. So I don't know what the 11th Circuit is going to do here, but the defense counsel here make a very good argument that it's not up to the executive branch to decide, oh, it's fine for us to release all of this stuff to the public and to the Congress in the middle of these men's trials, that they're on trial. The court is in charge of the case and the release of information that impinges on the case, especially if it's grand jury information, because that's what the rule says. And oh, by the way, none of the exceptions for release in the grand jury rule allow this either. Why isn't Cannon the one who's in charge of
It'd be
this?
interesting if to toy with the process to submit a proposed order that says the Attorney General may release the report, but no earlier than January 22nd.
Right, or 23rd or something. Yeah.
It,
Right.
to digress a minute, what is this that Smith or Garland want to release? It's evidence and conclusions drawn from evidence that was obtained by Smith and his team in secret in the grand jury through subpoenas and testimony, which is secret, through FBI interviews of witnesses, which are secret. Trump was not there and able to weigh in on whether this guy is credible, whether that evidence is even admissible against him, whether he's a lying piece of shit. That was not done ever, and
Right.
will not be done until there's a trial. So basically, Smith has turned it. Smith and Garland proposed with the risk still outstanding that Trump could be prosecuted, and these two individuals are still being prosecuted. Uh, what Garland proposes to do is to turn all that into a star chamber, one-sided procedure that concludes everybody's guilty as hell and put it
Right.
out in the
According to
public.
us, because
Yeah,
we say so. Right.
that's
Right.
kind.
Right. And it's both these cases partake of the same problem, which is they're both through the looking glass. Right. Both this New York case and the appellate courts there and all of this stuff about the report. It sentence first, verdict after. It's insane.
I go back to the point that I made. A competent trial judge with effective voir dire will be able to eliminate any potential prejudice that might result from the release of this information.
Uh-huh. Yeah. My
Isn't that
sarcasm
isn't,
meter
isn't that
has just
isn't that
exploded.
how we sleep
What?
comfortably at night as trial lawyers?
Yeah.
According to the
What?
circuit, right? According
What?
to the circuit in
What?
DC
Once
anyway,
upon a
yeah.
time, I've heard people talk about how serious a right is, the right to preserve one's good name, and this is a an effort through, as I said, star chamber type procedure to ruin the good name of a bunch of people.
Well,
Right.
in a very simple way, it's character assassination.
Yeah.
Exactly. Yeah.
Right. Straight up. Yeah. Now, as King and I were discussing on our thread earlier today, I guess, excuse me, the history has been, and I think Garland is a plotter, and he's just plotted his way into this, which is when these special counsel or independent counsel cases are done of these very high ranking government officials, at the end of the day, the report gets released because the Congress is going to demand it anyway, right? The public and the press clamor for it. You spent all this bazillions of dollars and all this time on this, public figure who was credibly accused of really bad stuff. And so, he's just going down that
And
same
all
thing
we got was a T-shirt with his mugshot.
right. Exactly. Right. And that's what's happened every time. And so he's thinking that's what we're going to do. And we need to do that before we're out of office. Okay. But I mean, glaringly obvious here, dudes, you still have people on trial. This is not at all the same situation.
What if it,
That they just are running roughshod over these two men's
what,
rights is just
what if on
ridiculous.
the 18th they moved to dismiss with prejudice as to Nauta and the other defendant,
Well, that they'd have a better argument,
and
wouldn't
then
they? That at least the investigation is finished, right? Like Durham did. He took his two shots. Seriously, didn't do a great job. His team of prosecuting them didn't get convictions, but okay,
I
case
I,
over. Now the
I
you know,
have
report
a
comes out.
there's still a story to be told there that I think we might finally hear with the change in administrations. That
Hmm.
it was communicated to me by somebody who should know but could not go public that Garland dramatically hamstrung Durham after the election and
Yeah,
cut Durham off from several avenues that they wanted to pursue that might have produced more better
more
prosecutable cases.
compelling.
Um,
Yeah, more
and
compelling
and
cases.
and
Yeah.
basically they gave him one shot in D.C. and one shot in Virginia but in cases that were, highly problematic.
Yeah, difficult cases. And then they didn't do a good job. I sat through several days of those cases, and they didn't do a
Well,
good job on them. Is
well,
the truth.
I want to add that there is also the magic of lawfare, which seems to jump from place to place. Because the same basically the same case against Trump in D.C. The underlying facts uh, are at issue in state criminal court
Atlanta.
in Atlanta and
Yeah.
in Arizona and maybe somewhere else, Michigan.
Michigan.
Yes. So uh, there are even though those people are not named as defendants in the D.C. election case, uh, their names are certainly there.
Oh, they're involved in
Yeah,
that fact pattern.
as
For sure.
unindicted
Right.
co-conspirators or what have you. So
Right.
uh, when the brush that will be tarring people's reputation is very wide and will cover all of the defendants in each of those cases, and uh, to use this process to one taint those other criminal cases and ruin or try to ruin people's reputation without giving any of them a right to say anything in response is to me is
Right.
outrageous.
I agree. The only thing that weighs on the other side to me is there is a legitimate point to be made that having spent all of this money investigating this shit and bringing these cases and all of this, the Congress and the people probably are entitled to see, well, okay, and what did that you produce there, the square root of fuck all,
Well,
basically.
the
But
answer is the indictment.
right,
That
no, I agree with
investigation
you. Yeah.
produced indictments, and they can trace what
Yeah.
happened to those indictments to the present time. There is no justification to go through the work product of how they got to the indictment. Eh,
Well, and they already did
Yeah,
that, didn't they? When they
yeah,
dumped all that shit in the
right.
DC
So
case.
there's no need, no purpose, no use for anything beyond
Right.
what's in the public record right now, uh, other than to, like through a star chamber type process, ruin
Right.
reputations.
Well, the obvious point for Smith and probably Garland and others is that, well, we couldn't get him because he had all these technical defenses and he got all these technicalities and all of this stuff and we ran out of time. But he's really still guilty. Read our report and you'll see it.
That's like a losing prosecutor at trial when the jury comes back and says not guilty. Well, let me show you public
All
all the
mad.
stuff the judge wouldn't let me show the jury. And let me
Right.
show you witnesses that I couldn't get to court because they were unavailable or something. And let me try my case to the public that I lost before the jury. What's the difference?
Right. Right. No, I know. Well, the difference is it's the lawfare, right? Which honestly, I never thought I would see. And I'm horrified that this is where the legal system has come to. I'm hopeful that with Trump in office, we're going to see a stop to it. But, will we see it again when he leaves office? I don't know. Well, that's the situation. We're going to wait to see what the 11th Circuit is going to do. I think they'll rule, maybe not tomorrow. Um, And they do have the backstop that Judge Cannon's order is temporarily, at least, holding the DOJ in place. But I don't think they can wait too long before making a ruling on that. What do you think the odds are that they'll just rule on it versus remanding it back to her as the defense requests for a bunch of factual findings on
I think
redactions
they sit
and
on it until after January 20th.
you do just don't want to deal with it and let's see if DOJ changes their
Exactly.
opinion.
Now, I
Yeah.
do have one question. Did the government's attorney take a position one way or the other as to whether Judge Cannon's order applies just to the Florida case, or does it cover everything Smith did?
Yeah. I think they avoid that. Let's see. Let me see to answer your first question. I've got the pleading pulled up finally. Let me see who signed this. Okay. This is signed by, for the government, it is signed by Brian Boynton, the Principal Deputy Assistant Attorney General, and Markenzie Lapointe, United States Attorney. And then another lawyer, Mark Freeman, who's on the appellate staff at the Civil Division. So Smith is not on here, and the special counsel's office does not appear as one of the entities either. So let me see. Can you still with me?
I'm here. The reason I ask that is that it's been reported in the news that Garland has announced that he intends to make public the D.C. election uh, case report.
Oh yes, they say that. They say that in this pleading that that's what their
Is that a
proposal is, to
proposal, or is
release
that
that part.
a statement of fact that that's what they will do come hell or high water, unless they're told not to?
Well,
I,
it's couched in the language that this is they're telling the court this is what they would like to
okay,
do.
that's interesting because it's being reported that they intend to do it, and almost like unless the court acts to stop them, they do not see Cannon's order as preventing them from, they're like the DC case is in the DC courthouse, not in the Southern District of Florida, and so she has no authority to prevent them from releasing the DC case, notwithstanding the kind of definitive nature of her order.
Right. Let's see. Well, you know what? I would have to read the language more clearly to to or more carefully to say exactly what it is as between those 2 points, because it's a nuance that the reporters are maybe not picking up on, that whereas lawyers we would disagree uh,
I,
with what they're
I
saying.
think just to speculate on the signature lines and the signature blocks you're seeing, I suspect that most of the members of the special counsel's office are basically in a use or lose situation with built up annual leave, and they
Oh
are
yeah.
resigning.
Oh, and or they're already private
So
citizens again. So here's the conclusion. Here's what the government asks. They ask that the court deny the motion, set aside the district court's temporary injunction, and make clear that there is no impediment to the attorney general allowing for limited congressional review of volume 2 as described above and the public release of volume 1.
in other words, they're going to do it. They're not asking for the court's permission. They're asking the court to simply make clear that they already have that authority. Read that again.
Right. Yeah. And there's a typo in it too. So I'll read it to you word for word this time. We respectfully request that this court deny the motion on the merits, comma, set aside the district court's temporary injunction in full, comma, and make clear that there is no impediment to the Attorney General allowing for limited congressional review of Volume 2 as described above and the publicly, there's the error, publicly release of
Yeah,
Volume
see, they're
1.
not asking for authorization.
No,
Right.
but implicit in that, I think, is the recognition that at least by its express terms, Judge Cannon's order prohibits them from making
From doing it
from
right
doing
this
it.
minute.
Yes, they,
Well, yeah,
because
Yeah.
because they're asking the order be set aside.
correct.
Yes. Yeah. Right. So the language makes it clear that they think that's what the answer should be, but they're not going to take any action until the court tells them that they're right. So we'll
Yeah,
see
and
what they
I think
do.
that's the appropriate, prudent uh, way to go, because uh, when you have a court issuing a order that's broad and blank, as a blanket covers everything, you are risking a lot as a lawyer by saying, well, the judge didn't really mean that.
Right.
You either go back to the judge and ask for clarification, or you seek to get it reversed like they are here.
Right.
But
From the that court or a higher
okay,
one.
now though, I mean, I understand your point, King, and I see it could play out exactly like you said. But if Attorney General Merrick Garland defies the order and publishes the report and then leaves office, who has to respond?
Well, we know he won't be able to get removal because he'll be a former officer. So
Well, who gets to respond, or who is obligated to respond? The new Attorney General for
yeah.
the misconduct in office of the old Attorney General, or private
Right.
party, private citizen Merrick Garland, who walks
Right.
out the door with a pardon from Joe Biden in his back pocket?
Right. Yeah. Yeah, there was some reporting today that he is considering preemptive pardons, and I would normally kind of brush that off. But the last two times that he Biden was considering pardons, first for his son, and second for all those commutations for people who are on death row, there was this sort of trial balloon kind of reporting on it, right? It reads exactly the same way. Sources say he's considering this kind of like 2 days before it happens. And now we're seeing that today with respect to these preemptive pardons.
All right, time for me to go.
Yeah. Okay. Well, thanks everyone. We were going to do tomorrow as spaces on preview of the TikTok argument, but there's just too much going on with Trump's cases to do that. So I think I'm going to listen to the argument on Friday, and then one day next week, maybe over the weekend or early next week, we will discuss that so people can understand what's going on with it, but post the argument at this point. And we'll save tomorrow and/or Friday for developments in Trump's cases and this 11th Circuit special counsel report. So, King, you got any final words?
Uh, just
Do you have
I
hot
have
water?
hot water. I've
Woohoo!
enjoyed my new fresh hot water, and but I'm really distressed about what's going on in California. Uh, I
Yes.
feel for those people.
Yeah, it's horrible. So, all right, guys. Well, we will say goodnight for tonight and we will talk again soon.
Good
Thanks,
night.
guys.